The first thing people notice about the University of Connecticut School of Law is our beautiful Gothic campus. Because we have many buildings, we have wonderful indoor and outdoor spaces, giving us the feel of a small liberal arts college. Yet these spacious surroundings are located in the center of a vibrant metropolitan area, Hartford, Connecticut, which is also the capital of the state. This location provides our students with exciting opportunities for access to the state legislature, the state courts, both the Supreme Court and the appellate courts, the governor's office, and the Attorney General's office, and all the things you'd expect at the seat of government. You may wonder why I talk about teaching in a video celebrating faculty scholarship. Anyone who has ever stood in front of a classroom understands that to clearly explain things to people, you have to think them through on your own first. And there's no better way to do that than to put your ideas on paper, whether it's in a book, a scholarly article, even an op-ed piece. All these forums encourage authors to consider alternative perspectives and to be prepared to engage with opposing points of view. Our faculty have the added experience of traveling around the country and around the world, engaging with other scholars and testing their ideas in open debate. So by the time they return to campus, they know just how they want to present their ideas to the students. And our students have the joy of seeing faculty members who are excited about their work and eager to make a contribution to public understanding. That's why celebrating teaching and faculty scholarship go hand in hand. We are very proud of our faculty's productivity and the names of the publishers on the cover of the books. But what really excites us are the ideas inside, and that's why we are celebrating the year of the book. Phillip Blumberg is a marvel. He has done so much for this school. He was our dean, he hired many of our faculty members, he brought us to this beautiful campus, and of course he's taught countless students whose careers he has continued to bolster. In addition, he's a superstar scholar. His multi-volume treatise on corporate groups is the Bible in the field. And now, in his 90s, he's tackled a new subject. His new book, Repressive Jurisprudence in the Early American Republic, tackles the question of what did the founders really think about free speech. The curiosity he displayed in working on this new topic reflects something deeply important about him. He's always open to new ideas. He has conveyed that spirit to everyone here on campus, and we're so proud to have him among us.
Ultimately, I think the contrast between Phillip's method and his message. The Phillip's method may be traditional, but it is not old-fashioned. The lawyerly, case-centered analysis. In the past, routinely produced results that told us precious little about the world outside the cases. And to the extent they did, it was a picture of orderly, logical rationality. Morton Horowitz was really the first legal historian to read cases and see something dark and subversive in the world they came from. And so does Phillip. In essence, the title of his book is a tip-off, Repressive Jurisprudence in the Early American Republic. This is not going to be a celebratory history. Phillip applies this traditional lawyerly methodology, which used to be associated with reliably Whiggish narratives, and uses it instead to show us the founders at their worst. Struggling for political advantage, eager to suppress political opposition to maintain power, willing to sacrifice constitutional principles in the name of liberty, happy to turn on their opponents the same repressive weapons they had decried when their opponents had used them against them. This is a very modern message, a very modern interpretation, indeed even a Horowitzian one. Now, Phillip does not shy from it. He describes an overall repressive legal system. Those are his words. that was fundamentally at odds with the political ideals of the Revolution.
I became interested in the Alien and Sedition Act of 1798, which by all accounts was the worst statute ever passed by the Congress. I couldn't imagine how a Congress could have passed the act and how the courts could have applied it. And when I started working on that and found the explanation of that, I discovered this was just the tip of the iceberg, because what was involved was the extent to which the English common law was affecting the development of American law. We started with the colonies, and they were English colonies, and they had English law, and the day of independence, the law of the new state became the same as it had been the day before. And that meant that all the English doctrines built to support an absolutist monarchy that was gradually losing its power became law for a new country that was based on entirely different political principles. And this struck me as extraordinary, and I discovered that that law, with respect to freedom of speech, was American law for 150 years. Hard to believe, supported by judges like Justice Holmes, though he later regretted what he had said earlier. And at the same time, the country went on its normal democratic way, and the law enforced only episodically. So this became a fascinating story, and that I tried to explore in all the dimensions that are involved in the First Amendment to the Constitution, which is the one that assures people of freedom of speech. Freedom of speech meant nothing other than the fact that you could say what you want to without getting a license from the government. It didn't mean that you might not go to jail for what you said, and under the Alien and Sedition Act, and for 150 years later, people went to jail. Astonishing. And a similar history is found with respect to so-called freedom of religion. The law of blasphemy was American law until well into the 20th century. It was accepted principle in English law and in American law, supported by people like Supreme Court Justice Joseph Story, eminent constitutional authority. Of course, Christianity is part of our common law. So much at war with the political principles on which the country was founded. So it's this conflict between the law and the political principles of the Revolution that got me engaged and had me launched on the book. I'm glad to say this is all ancient history, but the fact that it was history for 150 years makes us all think very hard. It certainly has made me think very hard, and that's the book.